Mr. Sethi, Ms. Berry and Ms. Breslin appear for the respondent, Mr. Basfar, a diplomat accredited to the London Embassy of the Kingdom of Saudi Arabia and currently serving, as I understand it, as one of the first secretaries there. Written submissions have also been filed, as the Court knows, by Kalyan, an NGO with expertise in the study of human trafficking, and by the UN Special Rapporteur on Trafficking in Persons. My Lords, my Lady, Ms. Wong's appeal raises the question left open by this Court's decision in Al-Malki and another against Reyes, and summarised by Lord Wilson in that case in the following terms at paragraph 56 of his judgment, EF, page 854. Does an action instituted in the Employment Tribunal against a foreign diplomat in the UK by his former domestic servant brought to the UK to work in his home in assumed conditions of modern slavery relate to any commercial activity exercised by him here outside his official functions? Now, as the Court knows, in Reyes, Lord Sumption and Lord Neuberger were of the view that the question was to be answered in the negative, as Mr. Basfar, of course, contends on this appeal. Lord Wilson, Baroness Hale and Lord Clark, on the other hand, doubted the correctness of that conclusion and considered it to be at least a rational and legally respectable view that such an action did indeed fall within the commercial activity exception to immunity. Ms. Wong submits that that rational and legally respectable view should now be endorsed in this case as correct. Her case, my Lords, my Lady, involves three stages. The first stage is that human trafficking is itself properly characterised as a commercial activity. It is described by the government of this country as a form of modern slavery. It does not involve a one-off act, and it occurs over a prolonged period of time, and it yields a specific and intended financial benefit to its perpetrators. That is the first stage. The second stage of Ms. Wong's argument is that on the facts of this case, the allegations against Mr. Basfar are to the effect that he engaged in the human trafficking of Ms. Wong. Ms. Wong has expressly alleged in her claim form that she was the victim of trafficking at Mr. Basfar's hands, and 7 indicators of trafficking are formally pleaded against him. In those circumstances, we say, this action must be held to relate to trafficking. Now, although that conclusion, as the Court will have seen, is challenged by Mr. Basfar, it is, we say, consistent with the approach of both the Court of Appeal and the Supreme Court in Reyes, and indeed with that of the Supreme Court in Haunger before it. It is also consistent with the fact that the government has identified employment proceedings of the kind brought by Ms. Wong as one of the key means by which victims of trafficking may seek redress from traffickers. And the third and critical stage of Ms. Wong's argument is that in those circumstances, these employment proceedings should indeed be held to be an action relating to commercial activity exercised by the respondent. To go back to the question posed by Lord Wilson, within the ordinary meaning of those words, as set out in Article 31(1)(c) of the Vienna Convention on Diplomatic Relations. That is a conclusion which we say follows logically from the first 2 stages of the argument, and which is supported by the correct interpretation of each of the words commercial, activity and exercised, which the Court will have to consider. It is, we say, reached by application of the primary means of treaty interpretation identified in Article 31 of the Vienna Convention on the Law of Treaties. It is in accordance with the ordinary meaning of the words used, having regard to the context, object and purpose of the Vienna Convention on Diplomatic Relations. It is consistent with a range of comparative law cases as to the ordinary meaning of the words used, whether from the United States, Canada or Portugal. And it respects, importantly, we say, the principle of harmonious interpretation, or systemic integration, as it's sometimes called. Having regard to the full range of relevant international rules, embracing the law of state and consular immunity, and running through from the 1920 Anti-Slavery Convention right up to the Palermo Protocol of 2000, and then on to the ILO's 2014 Protocol to the Forced Labour Convention. Rules which I will come to, and which, so far as treaties are concerned, we've listed in the table which was sent to the registry on Monday with all the references, and which I hope has reached the court. But before addressing each of those three stages, my lords, my lady, I'd like, if I could, at the outset, to emphasise what we submit to be 6 central flaws in the way Mr. Basfar puts his case in response. First, we say he is wrong to contend that Miss Wong is somehow reneging on any agreement in founding her case on the allegation that she has been the victim of human trafficking at the hands of the respondent. That has been her case from the outset. It has been the assumed and agreed premise upon which the entire immunity debate in these proceedings has taken place, and it is also the correct approach in principle for the immunity issue to be determined on the basis of a claimant's case at its highest. Secondly, Mr. Basfar's argument that the employment of a purely domestic worker is to be characterised as within the diplomat's official functions is, we say, contrary to the unanimous view of the Supreme Court in Reyes, Lord Sumption at paragraph 20, Lord Wilson at paragraph 55. Thirdly, on the central question on this appeal, the meaning of commercial activity, Miss Wong's case does not seek a declaration that the entry by a diplomat into any employment contract involves the exercise of commercial activity. It is only her case that it is engagement in conduct meeting the international definition of human trafficking, the modern incarnation of the slave trade, which does so, and she need go no further than that. She contends, in other words, that the question identified by Lord Wilson that I highlighted at the outset of paragraph 56 is the material one, not the wider question which Mr. Basfar wishes to pose at paragraph 1 of his printed case and paragraph 5 of his supplementary case. Fourthly, Miss Wong is not asking the court unilaterally to amend the Vienna Convention on Diplomatic Relations, or to develop international law, or somehow to create a new exception to diplomatic immunity. She is instead asking the court to interpret an established but undefined exception, an exception specifically set out in the treaty in a manner which is in harmony with other provisions of international law, provisions binding on virtually the entire international community, including, importantly, both this country and the Kingdom of Saudi Arabia. Fifthly, Mr. Basfar is wrong to contend that Miss Wong's case would expose the United Kingdom's diplomatic agents to legal proceedings abroad in any way that is not already accepted and contemplated as legitimate and possible, even on the respondent's interpretation of Article 31(1)(c) and within the scheme of the Vienna Convention. If the concern invoked is the risk of exposure to trumped-up allegations, then that risk exists anyway, because Article 31 does not confer absolute immunity from civil proceedings on diplomats, in contrast to the way it approaches criminal proceedings. And in any event, any consideration of that public policy concern would have to have full regard for the fact that Miss Wong's case will have no implications whatever for what have been described by the Court of Appeal in the context of special missions immunity as a diplomat's core immunities, namely inviolability as to the person and his residence, absolute immunity from criminal process, absolute immunity from giving evidence, and certain forms of enforcement immunity. So against that background, my lords, my lady, I'll turn to the three key stages of how we put our case, if I may. Turning to the first stage of the argument, the commercial nature of human trafficking. This is addressed in the appellant's printed case at 8 to 13 and 43 to 44, at EF 317 and following, that of Kalyan at paragraphs 3 to 4 and 9 to 10, and that of the UN Special Rapporteur at paragraphs 22 to 24. The international definition of trafficking is addressed first at paragraphs 8 to 13 of our printed case, and that's EF 321. And it's, of course, a definition that was referred to by both Lord Sumption and Lord Wilson, as I know the Court will know. 6 aspects of that definition and its implications merit emphasis from the passages at 8 to 13 in our printed case. Firstly, trafficking is very obviously defined widely. It embraces a long chain of activity engaged in for the purposes of exploitation. It embraces the recruitment, transfer, harbouring and receipt of persons by means of deception or abuse of power or of a position of vulnerability for those purposes. And I should emphasise at this stage that in the present case, Mr. Basfar is alleged to have been involved in the trafficking in issue at every stage: recruitment, transportation, harbouring and receipt. He is no mere end user, no mere consumer, even if those concepts had any relevance in the context of human trafficking, which, given its definition, we respectfully submit they do not. And in any event, as Lord Wilson contemplated at paragraph 62 of his judgment, the ultimate recipient trafficker is the person who is the most culpable in the chain, driving the entire process, exploiting the victim, and extracting value from him or her. Now, I should say, perhaps in passing, harbouring is not a term which is defined in either the Palermo Protocol or the Anti-Trafficking Convention, but it's been described by the European Court of Human Rights in the VCL against UK judgment from this year as including the locking of someone in a property. And as a matter of dictionary definition, it of course extends to hiding, concealing, or keeping secretly.
Is there a reference for that?
I'll give you one, my lord, if I may. I haven't got it to hand. So that's the first point which we say merits emphasis from these passages in our printed case. Secondly, as the definition states, the notion of exploitation includes forced labour or services, slavery and practices similar to slavery or servitude. And as Home Office guidance has explained in this context, domestic servitude often involves work under conditions of humiliation, for exhausting hours, for little or no pay, precisely the kind of conduct, in other words, to which Miss Wong alleges she was subjected. This is all set out in our printed case at 10.3 EF, page 322. Thirdly, consent on the part of the victim is irrelevant, where one of the prohibited means, whether it be force, deception, or abuse of power and the like, is used. Fourthly, this definition is present in both the UN's anti-trafficking protocol, the Palermo Protocol, to which both the United Kingdom and Saudi Arabia, together with 176 other states, are parties, and in the Council of Europe's Anti-Trafficking Convention, to which all members of the Council of Europe other than Russia are parties. Fifthly, and this is our printed case at 11, as this EF page 322, as this court found in Haunger, paragraph 49 of the Haunger judgment, it is legitimate to have regard to the International Labour Organization's indicators of forced labour in determining whether an individual is properly alleged to be a victim of trafficking. And those indicators include issues such as deception, restrictions on movement, isolation, withholding of wages, abusive working and living conditions, and excessive overtime. And sixthly, the gravity of human trafficking involving the deliberate emotional and physical abuse of an individual. This is our printed case at 12. For deliberate and emotional and physical abuse of an individual for financial gain is aptly captured by the government's frequent description of it as modern slavery. An example of that is the Home Office guidance from 2019 at EF page 4433. As Lord Wilson explained in Reyes at paragraph 61 of his judgment, EF page 892, citing an earlier observation of the European Court of Human Rights in Ransef, to which I'll come, the vice of trafficking is that it treats human beings as commodities, to be bought and sold and put to forced labour, often for little or no payment. And I emphasise immediately, my lords, my lady, that characterisation of trafficking as modern slavery and as involving the treatment of human beings as commodities to be bought and sold is relevant not because we seek to displace immunity by reference to any superior rule of law or jus cogens norm. We entirely accept that the Jones case and the ICJ's jurisdictional immunities decision preclude such an argument. But the characterisation of trafficking as modern slavery is relevant instead, we say, because it assists our argument on interpretation, not creation of a new exception, but interpretation of an existing one. Any involvement in the slave trade should, we say, as a matter of interpretation, readily fall within the definition of commercial activity. It would have done so in 1961 when the Vienna Convention was signed up to, and its modern incarnation should do so likewise today. That characterisation as modern slavery is relevant too if, as the respondent submits, one of the touchstones of conduct caught by the Article 31(1)(c) exception, evident from the Travo, is whether it is conduct which is incompatible or inconsistent with or repugnant to the ordinary discharge of diplomatic functions, or likely to lead to the diplomatic agent being declared persona non grata. And it is also relevant because of the principle of harmonious interpretation we contend for and that I've already referred to, and the network of legal instruments relating to slavery and trafficking to which I will come. Now, as to the particular adjective commercial on this first stage of the argument as to whether trafficking itself is commercial, this is addressed specifically in Miss Wong's case at 42 to 43, that's EF 333 to 335, Kalyan's at 8 to 10, that's EF 414 to 416, and the UN Special Rapporteur's case at 18 to 24. What those paragraphs illustrate, we say, is that the global economic implications of trafficking are very substantial, as are the commercial benefits yielded by individuals involved in such practices. This is right.
Necessary, isn't it, Mr. Otte, to distinguish, though, between the global activity and the facts of this case? I mean, one may say that the global amount of trade in bars of chocolate is very large, but if I go and buy a bar of chocolate, that doesn't mean I'm engaged in a commercial activity.
Well, I appreciate that's the key question, my lord.
That is the key question.
That is the key question. But it's right also to say that the international materials, the ILO materials and others, also emphasise the very significant financial benefit yielded by employers in this context. So it's not just an industry-wide observation. It's talking about the scale of financial benefit yielded by individuals in Mr. Basfar's position. And that is, we say, important as a matter of analysis. But the key question my lord has identified is one I entirely acknowledge I have to confront and grapple with, but I seek to do so more at the third stage of my argument. The first stage of my argument is that we are dealing with something which is inherently commercial in a general sense, trafficking. And the figures are set out there. The EAT, indeed, in this case, rightly described trafficking as an abhorrent trade. That's paragraph 78 of its judgment at EF 458. The scale of the industry is estimated to generate illegal profits of $150 billion a year, of which more than a third are estimated to be related to forced labour. That's EF page 333. The ILO, which, as I've said, both the UK and Kingdom of Saudi Arabia are members of, has estimated that earnings of the order of $8 billion are effectively stolen from domestic workers in forced labour around the world annually. And it is described, trafficking is described as the second or third most profitable of all illicit trades, behind only the illegal drugs trade and the arms trade. But as I say, I entirely acknowledge I can't simply sit down and stop there, but it's an important first stage of the argument to acknowledge, we say, the inherently commercial nature of what is going on here. And that much didn't, in fact, appear to be the subject of a significant difference of views between the members of the court in Reyes. We say Lord Sumption was right to express the view, at paragraph 45 of his judgment, EF page 887, that if an individual engaged, for example, in the recruitment or transport for reward of a trafficked person, that would be to exercise commercial activity. Likewise, he was correct in the same paragraph to indicate that if an individual received a trafficked person for, say, prostitution, that would be to exercise commercial activity. So on this first stage and this first question of whether trafficking itself is commercial in nature, we submit that there should really be little doubt. So I turn then to the second stage of the argument, which I should say until it came to the process of drafting the statement of facts and issues for the purposes of this court's deliberations, we hadn't actually appreciated was even an issue. The second stage of the argument is that on the facts of this case, the pleaded allegations against Mr. Basfar are that he subjected Miss Wong to human trafficking, and that her claim accordingly relates to trafficking. Now, as I say, this is now an issue between the parties, but we still submit it should not be a difficult question to resolve in Miss Wong's favour. As I've already said, and we've explained in our printed case at paragraphs 27 to 33, in determining a plea of immunity, it is entirely conventional and correct to take a claimant's allegations at their highest and to ask whether, if made out, immunity would apply. That was certainly the approach taken, and we say rightly taken, by both the Employment Tribunal at EF page 461 and the Employment Appeal Tribunal at EF page 431. The Employment Tribunal proceeded on the express basis that the claimant is a victim of trafficking who was exploited by the respondent and his family. That's the ET Judgment 5 to 14 at EF pages 462 to 3. Likewise, as the Employment Appeal Tribunal put it at paragraph 3, and as we say in the printed case at 19, Mr. Basfar's strikeout application, quotes, proceeded on the agreed basis that the claimant's case should be considered at its highest, i.e., on assumed facts as pleaded. In essence, and this is how the EAT puts it, in essence, this is that in circumstances of modern slavery, the claimant was trafficked by the respondent to the UK in order to work as a domestic servant in his diplomatic residence. And again, at paragraph 5 of VAT's judgment, it recorded, the reference for that is EF 435 to 436. At paragraph 5 of the EAT's judgment, it recorded the agreed premise for the immunity debate as being that the claimant's treatment amounted to modern slavery, and she was a victim of international trafficking exploited by the respondent and his family. Now, that summary and that approach was entirely justified, we say, on the basis of the allegations made. And in that regard, we've set out the factual background to Miss Wong's case in our printed case at 14 to 19, EF pages 324 to 326. And looking at the ILO indicators of forced labour, which we set out just a couple of pages before, at paragraph 11, EF page 322, at least 7 of them are present on the pleaded facts asserted by Miss Wong as summarised in paragraph 16 of her printed case. So back to EF page 324. We have coercion, abuse of power and vulnerability from 16.1, 16.3, 16.7 to 9, and indeed 23.2 of our printed case. We have deceit, 16.1, 16.2, and again 23.2. We have restriction of movement, 16.8 and 26. We have isolation, 16.8 and 9. Withholding of wages, 16.3. Abusive working and living conditions, 16.3 to 8 and 23.3. And excessive overtime, 16.4.
Yes, I can see that those amount to exploitation within the meaning of the Palermo Protocol definition. But it's whether the allegation is that the respondent actually engaged in trafficking her rather than exploiting her, which I think...
Yes, my lady, I see that. For those purposes, we've got really two points. One, the ET1 expressly alleges that she was the victim of trafficking at the hands of the respondent. Secondly, we've got Haunger, which I've already referred to, the Supreme Court saying it is legitimate to have regard to the ILO indicators, which my lady has just referred to, as a guide to whether trafficking is in play or not. But I take my lady's point. The ILO indicators are focused on what is forced labour. And they're telling you definitively the answer to that. We move from there to trafficking by virtue of the ET1 itself and the allegation in that, by virtue of Haunger, paragraph 54, I think it is, saying, Lord Wilson saying you're entitled to take into account the ILO indicators in deciding whether trafficking's occurred. And we have the ET and the EAT saying the agreed premise for this debate is that Miss Wong was the victim of trafficking at the hands of Mr. Basfar.
Yes, it's the at the hands of Mr. Basfar, which is the...
And that's the allegation.
Yes.
Now, I emphasise, of course, all of this assumed for the purposes of the argument. No findings made, but all of it assumed on a conventional approach to immunity.
Insofar as it's assuming facts, do you then go back to actually have a determination? Facts.
Well, that's one approach, my lord. You can have it, even in the immunity context, you can have a preliminary issue on particular facts, and then you end up with a view as to whether immunity applies or not. But unless you take an approach which certainly none of the justices in the Supreme Court in Reyes considered attractive, and we'll see a very similar argument was raised in Reyes and not even responded to in the judgments. Unless you take an approach that a diplomat is essentially immune by way of assertion, you can never resolve this issue, because a diplomat could always say, even forgetting about trafficking for a moment, even if we're in entirely undisputed conventional commercial activity territory, a diplomat could say, well, I didn't do that, so the exception doesn't apply.
And what should be the procedure then? Should the diplomat identify at the earlier stage that he does dispute the facts? And so that there could be a fact-finding hearing.
He should certainly do that, my lord. He should certainly at least identify which of the alleged... Forget about characterisation for a moment. He should certainly identify which of the alleged primary facts he disputes. And what he certainly shouldn't do is allow the Employment Tribunal and the EAT to proceed on the basis of an agreed premise of the kind I've shown the court. Now, in Reyes, as my lord may have seen in the disposition paragraphs of Lord Sumption's judgment, he raised this problem that my lord has raised, and he explained that he thought it was unsatisfactory for everything simply to go back down to be debated as a matter of fact. And so as a first stage, and the question the court was there grappling with was what was within official functions. As a first stage, Lord Sumption said, well, we want to hear further submissions from Mr. Al-Malki as to what he actually disputes as to the nature of Miss Reyes' employment, so that we can decide for ourselves whether there's even a live issue about this. And in the end, the court decided there wasn't a live issue, and so it was happy to conclude there was no immunity. So that would be one approach. But the one thing you can't do is say, as a diplomat, in rounds 1 and 2, yes, assume against me that Miss Wong is the victim of trafficking. Assume against me that she has been transported and brought to this country by me for the purposes of domestic servitude. And then on appeal say, no, you can't proceed on that basis at all.
Just pursuing that point by my Lord Stevens, that the difficulty is with your answer that in any case where there's an allegation of commercial activity, there may need to be some fact-finding. When one looks at the allegations in the ET claim and thinks forward about how one would go about that kind of fact-finding mission, they do raise issues of very intimate detail of the diplomat's household, that she was shouted at by the respondent's family and called offensive names, not allowed to call home, not allowed out of the house. Now, how does that get resolved? Or do you say that a hearing at which evidence will need to be called by Mr. Basfar, perhaps of members of his family, wouldn't amount to a violation of the diplomatic mission?
No, if it was A, being held in order to determine whether he had immunity, and B, there was no element of compulsion against him, then there could be no suggestion whatever that it was interfering with the Vienna Convention. My lady, and we can go back to this if needs be, but it's entirely conventional with respect. It's the approach taken in Jones, even involving the most serious possible allegations of torture, that the debate about whether immunity exists takes place on the premise of the claimant's allegations. Otherwise, you can never have anything other than a yielding to a diplomat's assertion of immunity.
Well, yes, but here you're drawing a distinction between immunity existing if it's slavery or exploitation within the Palermo Protocol,
yes,
but immunity would still exist if it were an ordinary employment relationship.
Well,
and that I think is the difference, that in order to have a fact-finding hearing to identify which side of the line the case fell on, you are requiring the diplomat to give a lot of details about the domestic arrangements in his home.
I see that, my lady. And it's in that instance, perhaps, that Lord Sumption's approach to this position is most useful and most telling. Because remember, in Reyes, the critical issue which was leading to possible remission to the Employment Tribunal was whether Miss Reyes' employment was within official functions or not. Because that was the nature of the residual immunity which would not exist if her employment was outside official function. So that was the key issue that would have to go back if there were a live debate about it. No member of the court had any problem as a matter of law with that being the right approach, even though in that context, the nub of the issue will be likely to be much more, or potentially much more sensitive in diplomatic terms than how many hours did you work? Were you required to wear a bell? Where were you allowed to sleep? Where could you eat? Because in that context, the critical issue is what was the nature of your functions? What was the actual work you were doing? Were you doing anything of a sensitive sovereign nature? But even in that context, Lord Sumption had no difficulty with the issue going back to be determined by the Employment Tribunal as a prior step to ultimately determining immunity, even if there was a factual issue. But stage one was, well, let's see if there's actually a factual issue here. And stage one, therefore, would be here let's see if there's a factual issue as to the nature of the employment conditions alleged, the nature of the recruitment, the fact of transport, the allegation of deceit, and so forth. That will be stage one, to see whether there's even an issue.
There's no, I mean, it's difficult to think of any hard and fast procedural approach to the problem of the assertion of immunity, because the immunity exists not only for the purpose of protecting a diplomat from a court order made in the receiving state, but for being exposed to litigation in the first place, because both of them in different ways may detract from the efficient performance of his diplomatic functions. So there may be cases, surely, where the right procedure is to say, well, let's assume all the facts against you, Mr. Diplomat, but you've still got an arguable case in law that you're immune, even if they were all facts. There may be other cases where surely whether he's immune actually does depend upon facts in issue, in which the court will perforce have to have a fact-finding exercise in order to resolve the immunity claim.
I agree, my lord, and I hope we fairly acknowledge that in our printed case, where we have explained the range of options open to a court when confronted with immunity. And one of them is, as my lord says, well, we're going to have to grasp the nettle here. And I think it's the International Tin Council case, J.H. Rayner, where Lord Justice Ralph Gibson is saying, well, there's a live issue here that we've got to determine as a prior step to deciding whether immunity applies or not. But there's nothing inherently inappropriate with that.
Yeah, but in this case, you're simply saying, well, in both the courts below, it was...
Well, that should be that, my lord.
The procedural approach was treated as, let's proceed on assumed facts.
My lord, yes. And we say that was the procedural approach adopted. And secondly, that is within the range of proper options open to a court when confronting an immunity debate. And that is enough for our purposes.
But it was Mr. Basfar who chosen this procedure, isn't it?
Well, exactly,
Didn't he apply to strike out the claim? So he was saying, well, I want to say that even if you were able to prove all these things, I'm immune, and therefore, please, court, decide that.
Precisely, my lord.
He's chosen that.
He's chosen that, and that's why we
can't now mess around saying, I'd like some other procedure, please,
by
the time you get to the Supreme Court.
Well, was it in form a strikeout application?
Well, it's described as a strikeout.
I'm looking at paragraph 4 of the agreed statement of facts, where a preliminary hearing was listed to determine the issue. I mean, that doesn't sound like a strikeout hearing. But I haven't looked at the...
Page 462, paragraph 2 of the Employment Tribunal judgment. This preliminary hearing was listed to determine the respondent's application to strike out all the claimant's claims. So if that means what it says, then he was actually applying.
And while we're on that page, my lord, paragraph 5, the respondent agreed the claimant's pleaded case should be taken at its highest. And if one wanted any, the position doesn't, the waters don't muddy when one goes to the EAT either. If we go back to EF page 435, paragraph 3, the application proceeded on the agreed basis that the claimant's case should be considered at its highest, i.e. on assumed facts, as pleaded in her ET1 claim. In essence, this is Mr. Justice Sewell, in essence, this is that in circumstances of modern slavery, the claimant was trafficked by the respondent to the UK in order to work as a domestic servant in his diplomatic residence. Now, no appeal against that finding or that approach.
But the point is relevant not only on this initial preliminary issue about what is Mr. Basfar bound by, but as to this, your case that in interpreting commercial activity, one can distinguish between employment at slightly below the national minimum wage, for example, and trafficking, and contemplate a fact-finding hearing in a future case in which a tribunal will have to decide whether allegations made and strenuously denied by the diplomat have to be resolved in order to decide that immunity exists.
My lady, yes, I accept that. And that's why I don't rest our position solely on the, well, you got invited this procedure and you said that was the right premise approach. I say, as we've explained in our printed case, that's entirely conventional in grappling with immunity issues, to go down either this route or the other route that my Lord Briggs has identified, of saying you've got to actually determine a discrete issue of fact in order to then decide whether immunity applies. There's no difficulty with that, and there's nothing unconventional in that. But I entirely accept, my lady, that why I proceed in the way that I do on the three-stage argument, that this agreed premise, this taking of the claimant's case at its highest, that this is trafficking, is an important foundation of our third stage. I entirely accept that. But we are of necessity dealing here with a disputed interpretation on assumed facts. There we are. We say, with respect, there's nothing unconventional or difficult with that.
Well, I don't want to take up too much time, but page 494 is the respondent's reply to the application. And at paragraph 4, he applies to strike out the claim.
Yes, again, it supports the strike out. And on all of this, one issue in which this all crystallised was whether or not Miss Wong should serve further evidence about her allegations, whether her witness statement should go before the tribunal or the EAT. And that was said to be unnecessary because of the agreed premise of debate. Now, as we've explained in the printed case, that witness statement explains further aspects of dependency. It explains withholding of Miss Wong's passport and the like. But we don't need to get into that level of granular detail because of the assumed premise, and because, as I say, it falls within the conventional approach to immunity. Now, Mr. Basfar takes a whole number of pleading points in his printed case about this issue as well. He says Miss Wong's claim can't proceed on the basis of allegations of dependency because there aren't any such allegations in her printed case. Well, with respect, we find that hard to see in light of allegations as to her working hours, her lack of pay, her isolation, and her confinement. He contends that there were no allegations that Miss Wong was recruited or brought to the UK by the respondent. Well, you've seen what Mr. Justice Sewell said about his understanding of the essence of Miss Wong's case. Now, I could go through all of these pleading points one by one, but I don't want to take up too much time unless it would assist the court on this, because it's really stage 3 that I want to get to. And I'll move to that, if I may. But perhaps one point to emphasise, aside from the pleading points, Mr. Basfar also says, and this is in his argument at 78 to 84, that none of the statutory causes of action that are relied upon by Miss Wong themselves necessitate a finding of trafficking to be made out. He says that the Employment Tribunal has no power to determine whether an allegation of trafficking has been made out. Now, we submit that that approach is simply wrong as a matter of principle and contrary to the approach of both the Court of Appeal and the Supreme Court in Reyes, and as I said earlier, also to the guidance available from the Supreme Court in Haunger. And the key point is this: if the factual allegations advanced by an individual in support of their claim are sufficient, if established, I emphasise if established, to meet the international definition of trafficking, then the claim must be held to relate to trafficking, notwithstanding the fact that individual causes of action don't need to use that word. And any narrow approach, we say, should be rejected as technical in the extreme and of no merit. Now, in the Court of Appeal in Reyes, Lord Dyson accepted, with express reference to Haunger, that there was force in the submission that we advanced there, that it would indeed be an overly technical approach to contend that since the formal causes of action relied upon by Miss Reyes lie in the field of employment law, her claims do not relate to trafficking. And that's Court of Appeal 31 to 32 at EF, page 837. Now, despite that finding in our favour, in the Court of Appeal. The respondent diplomat in Reyes then advanced a close cousin of the argument that Mr. Sethi advances today, because he contended, Mr. Al-Malki contended before the Supreme Court that the Employment Tribunal had no jurisdiction to determine claims of trafficking and relied upon the fact that no specific allegation of trafficking had been made, because in that case the word hadn't even been mentioned in the ET1. And indeed, that no findings, my lady's point, that no findings of trafficking had been made by that point. Now, that argument is recorded in the law report at EF, page 866. No part of Lord Sumption's judgment or Lord Wilson's judgment even referred to it, let alone accepted those submissions. And they should gain, we say, no greater traction now. On the contrary, as the Court knows, the particular and definitive focus of both Lord Sumption and Lord Wilson was instead on what was meant by the words commercial activity, and in Lord Sumption's case, exercised. And their judgments each proceeded on the basis that if trafficking was to be treated as commercial activity exercised by the diplomat, then the employment law claims would indeed constitute an action relating to such activity. And so it's those issues, the ordinary meaning of commercial activity, the ordinary meaning and significance of the words exercised by, that we say are the critical ones on this appeal. And it's those that I want to turn to now in the context of the third stage of my argument.
Just before you do, you presumably say that a tribunal, be it the Employment Tribunal or any other tribunal, must have power to determine a question of fact which goes to the existence of its jurisdiction.
Exactly so, my lord. Otherwise, as I said...
If you're right at stage 3 in saying if it's trafficking, then it's within the exception to immunity, so that you have to show whether or not it's trafficking, then you presumably say, well, if that's the peg on which a claim of immunity hangs or falls, the tribunal which is said not to have jurisdiction is going to have to determine it.
It's going to have to determine it, my lord. To give a completely different and, I hope, uncontroversial example, assume that we were dealing with what was, as I say, an uncontroversial commercial act. And the only question was whether the engagement in that act constituted commercial activity. And the diplomat, for example, saying, well, I only did it once, so it can't possibly be activity. There has to be more duration than that. And the response is, well, actually, you did it 10 times. Here's the evidence showing you did it 10 times. Is the tribunal really say, well, sorry, I can't look at that, can't determine that issue? It doesn't work, my lord. We respectfully submit it's inherent in the entire scheme, indeed, the entire scheme that the delegates must have had in mind when agreeing an undefined term like commercial activity, that it's going to fall to a court to determine that question, just as it does in any ordinary state immunity case where one's dealing with the classic jus imperii, jus gestionis distinction. The court's going to have to decide which side of the line it falls. Benkebush is another example, decided on the same day as this case, where the critical question is, was the employee discharging sovereign functions or not? You need to look at the actual functions. Now, that may give rise to disputed issues of fact, but the court can't simply avoid that and say, oh, well, have the benefit of the doubt and have immunity. So, as I say, my lords, my lady, that takes us to what is the key third stage of the argument, and the question, identified rightly by Lord Wilson, we say at paragraph 56. And we say that Miss Wong's Employment Tribunal proceedings should indeed be held to be an action relating to commercial activity exercised by the respondent, and so within Article 31(1)(c) of the Vienna Convention on Diplomatic Relations. She says that she gets quite a long way to that destination as a matter of straightforward logic from the first two stages of the argument. Trafficking is inherently commercial. Her claim relates to trafficking. But I accept that we need to look at the issues that my Lord Legate identified in his first intervention this morning. And we say that she gets to that ultimate destination clearly once one correctly applies the Vienna Convention on Law of Treaties and determines the meaning of the Diplomatic Relations Convention. And as to this, and as we've explained in our printed case at paragraphs 38 to 39, Ms. Wong accepts that in circumstances where the relevant words requiring interpretation, while formally part of a United Kingdom statute, are themselves drawn from an international treaty, the primary source of rules of interpretation are those set out in the Vienna Convention on the Laws of Treaties, and in particular those set out in Articles 31 and 32 of the Vienna Convention on the Law of Treaties. Now, those articles are at EF pages 613 to 614, and they make it clear that the starting point of what is called in the heading the general rule of interpretation is very simple. It is to interpret the treaty in good faith and to identify the ordinary meaning of the words in their context and in light of their object and purpose. Context is then defined by Article 31(2) as embracing in particular the text of the treaty, including its preambles. And Article 31(3)(c) then requires that in addition to context, account has to be taken of any relevant rules of international law applicable in the relations between the parties. And finally, Article 32 sets out the approach to what are called supplementary means of interpretation, either to confirm the meaning so far arrived at, or to determine the meaning if the outcome of the Article 31 exercise has left an outcome which is ambiguous, obscure, absurd, or unreasonable. And I'll go through each of these elements of both the general rule and the supplementary means later, if I may. But I'd like to attempt to preview what I have to say by reference to each of the points made by Lord Sumption in paragraphs 21 to 26 of his judgment, because it appeared to us that in those passages, Lord Sumption was setting out 6 factors which appear to him, or appear, I should say, to have led him to the conclusion he arrived at in relation to the proper interpretation of each of the 3 words I've mentioned, commercial activity and exercise. Now, paragraph 21 is at EF 876 to 877. And we have, first of all, 21.1, Lord Sumption stating that an activity was not the same as an act, a point I alluded to earlier, and it had to have some continuity and duration. There are, we say, 3 reasons in summary why, as a matter of ordinary meaning, that presents no insurmountable obstacle to Miss Wong's case.
You accept that proposition, presumably? Lord Sumption's proposition?
Well, not entirely, my Lord, because as we'll see from the Travo, which I know Mr. Sethi's keen to go to, one of the observations made by the Special Rapporteur on the International Law Commission was that a single plunge into the waters of trade was sufficient. I accept that there is, as I would be bound to, but in any case, I accept this is an issue that has to be grappled with, activity. But as we'll see, neither the International Law Commission...
It's satisfied by continuous...
It's certainly satisfied by that. The question is whether it will be satisfied by a single act.
Okay.
And we'll see when we get to it, for example, that United States courts, in considering the Foreign Sovereign Immunities Act definition of commercial activity for the purposes of deciding state immunity, the United States courts have no difficulty in characterising entry into a single employment contract as constituting commercial activity. So the point only goes so far is perhaps a better way of responding to my Lord's question. We accept the point has to be addressed, but it doesn't take Mr. Basfar home or Lord Sumption's analysis home for 3 reasons. Firstly, we don't even need to get there in terms of the material distinction on the facts of this case, because the conduct Miss Wong complains of was indeed of a certain continuity and duration. Her allegations span a period of some 2.5 years, from November 2015 to May 2018, and her particular allegations of abuse in this country occurred on the assumed facts repeatedly and on a daily basis from August 2016 to May 2018. She alleges that she was indeed the victim of a deliberate and continuing course of conduct and sustained exploitation, not just a one-off act. Secondly, on this question of continuity, and as Lord Wilson explained at paragraph 62 of his judgment, a rational view, as he put it, we would say the correct view, is that the relevant activity is not just the so-called employment, the single act of entry into the employment contract, but the trafficking as a whole. And that the employer, even assuming a case where it's employer only, end user only, if you like, the employer is an integral part of the chain. Now, in the present context, as I made clear at the outset, the allegations are that Mr. Basfar was involved in the trafficking at multiple stages. He was not, on the assumed facts, acting as a mere employer or end user.
But your case is end user is sufficient, is that right?
End user would be sufficient given the international definition of trafficking, but we're not dealing with an end user situation here in circumstances where the allegation begins with recruitment and transport, runs through exploitation and receipt and harbouring in this country.
Taking your client's allegations in the round, she's not really alleging a contractual relationship at all. The contract was formally produced in order to get her a visa, but bore no real relationship with what was going on within Mr. Basfar's home. It was a sort of fig leaf.
That's right, my lord.
And that's your pleaded case.
That's what it boils down to. And then once she's here and she's working under those conditions, that triggers a whole range of English law entitlements in terms of damages because of the lack of pay, the lack of rest time and so forth. But it's not simply a breach of contract claim in that very narrow
One has
sense.
to be careful that if she had managed to escape on day 2, once she had realised what the setup in the diplomatic home was going to be, and she had managed to get away, one wouldn't like to end up with a situation that was not an activity, because the exploitation only lasted for a short time, whereas here she says she only managed to get away after some considerable time. I mean, that would be an unfortunate
yes, and one wouldn't need to get there because of my second point and Lord Wilson's rational view that we're talking about the entire trafficking chain here in determining what activity the diplomat is or isn't involved in. I'll come to exercise and so on.
So you would say the diplomat who brings the person over and engages them, uses them on exploitative terms for whatever period of time, at that point it is a commercial activity.
The definition of trafficking has been met by the transport and the receipt, however long the harbouring then takes place for.
Yes, but here we're concerned with whether it's an activity.
Yes.
And I suppose you could say that even if she escapes after 2 days, it's an intended thing that's going to last for a long time, and that's still an activity, even if it stops prematurely, so to speak.
That's exactly it, my lord. That's exactly it. To go back to the 1920s, assume the diplomat buys a slave and brings the slave to his home to work under conditions of slavery. That doesn't cease to be, we would say, involvement in the slave trade because Somerset's case is brought and Lord Mansfield directs that the slave is to be freed. What matters is that there is the intent on day 1 for the exploitation meeting the definition.
How does the exploitation feed into the test? I can see that it's commercial, but can be said to be commercial because the respondent is profiting continuously from the employment, or whatever you care to call it, the servitude, let's say. But does the abusive nature or content of it affect whether it's commercial?
It's part of the matrix which shows how value is being extracted. And that's perhaps what takes it away from any, we would say, any adequate comparison with simply the employee who's not being paid the minimum wage. This is on the assumed facts, someone who is being held in confinement and required to deliver services of value on a daily basis. And that necessarily has abusive connotations to it, but it's the combination of the extraction of value and the impossibility of escape on the part of the person, the modern-day slave, that combining show on any view commercial activity is made out. I should say, we don't concede that even entry into an employment contract would not be commercial activity. My point is we don't need to go that far, because this case is just about the trafficking context. The final point on this, the third...
You may not have conceded, but you're not arguing this.
You're
not asking us to decide that point.
No, I'm not asking you to decide that point.
So if you lose on the main point, you don't have a fallback position that we have to deal with.
I have you down as saying, it's one of your three introductory points, we don't say that any employment is commercial activity.
Yes, I think I hope I went on to say we don't need to go that far.
Well, maybe. I'll add that.
Anyway, my lord's absolutely encapsulated our position on it. The third point on this question of continuity and multiple acts as opposed to single acts and so on, we say actually the answer is evident even from Lord Sumption's judgment. Paragraph 45 of his judgment, jumping ahead from 21.1 to 45, the passage I referred to earlier, he says one would expect an intermediary who recruits or transports a trafficked person for money to be exercising a commercial activity. The same is likely to be true of someone who receives a trafficked person for, say, prostitution. So in both of those instances, Lord Sumption is at least contemplating that a single act may be sufficient to constitute commercial activity.
But isn't it then the prostitution which is the commercial activity rather than the...
Well, no, because he's there talking about the receipt of a trafficked person for a particular purpose on one occasion. And maybe the analogue applies, in fact, my lady, in some senses, in that what matters, as my Lord Legate observed, is what's intended. Is it intended that something's going to continue? And that alone, that tension between 21.1 and 45 of Lord Sumption's judgment illustrates, we say, even looking at the four corners of Lord Sumption's approach, that this factor can't be given decisive weight.
You could say, well, what's the difference between an intermediary who transports a person for money and somebody who does it for their own benefit?
Exactly.
Their own including financial benefit.
Exactly so, my Lord. Both in terms of the content of the activity, or the characterisation of the activity, and the singular versus plural debate. And then there's the further point I made earlier in responding to my Lord Legate earlier. I'll just give the reference for it. I should have said the chairman, not the special rapporteur of the ILC, stated in terms during the course of discussion of this article that a single plunge into the waters of trade might be sufficient for the exception to apply, and we'll come to it later, but it's EF page 4181. So that's 21.1. 21.2, Lord Sumption, this is going back to EF page 876, Lord Sumption emphasised the word exercise, and he drew upon his own researches conducted after the hearing as to what a French-English dictionary said of the meaning of the French word exercer, in support of his conclusion that the exercise of commercial activity meant carrying on a business or setting up shop, as he put it. Now, we would of course accept that Lord Sumption's example of setting up shop would be within the concept of the exercise of commercial activity. But that does not establish, we say, that the concept should be so confined. And we contend instead that to treat the exercise of all commercial activity in the modern world as exhaustively captured by that kind of terminology is, with respect, too narrow. And again, we make three core points, each of which I'll seek to develop in a moment, but just to flag them now. First of all, the Court of Appeal in Reyes itself was prepared to treat the word exercised as equivalent to engaged in, as indeed later in his judgment was Lord Sumption. Now, there can be no doubt here, if Miss Wong's allegations are made out, and having regard to the international definition, that the respondent, Mr. Basfar, engaged in trafficking. Secondly, and insofar as the verb to exercise is to be equated with to carry on, as Lord Sumption's citation of Harrop suggests, it is, we say, entirely consistent with Miss Wong's case. And she gains further support in that regard from the United States authorities on state immunity, which I'll come to. And thirdly, Lord Wilson, Baroness Hale and Lord Clark certainly did not, for their part, consider this point to be conclusive in favour of Lord Sumption's analysis for the reasons they gave at paragraph 61 to 62 at EF page 892. Now, as to the first of those points, to the effect that exercised need mean no more than engaged in, the material passage in the Court of Appeal's judgment is in Reyes is at paragraph 34, EF page 838, by letters E to F, where without any challenge from the other Saudi diplomat, Mr. al-Malki, involved in that earlier case, the Court of Appeal defined the key question as whether a particular diplomatic agent who employs a particular trafficked employee is engaging in a commercial activity. That's the question, as a matter of ordinary meaning. And there's no magic and no critical answer provided by the word exercer or exercise. So far as Lord Sumption himself is concerned, he himself deployed the terminology of engagement in commercial activity at the end of paragraph 45, EF page 887, where he was discussing his suggested analogy of a fence handling stolen goods, and he referred to the fence as engaging in commercial activity. Now, I'll come back to this, but I of course emphasise that we say, with respect, that Lord Sumption's analogy of the fence is in any event flawed, for the reasons essentially contemplated by Lord Wilson at paragraphs 61 and 62 of his judgment. By reference,
more or less the same thing, these words. They're just synonyms for do. You know, you do the activity, or you perhaps wouldn't say that. You perform, conduct, carry on, engage in.
But that's
different ways of saying the same thing.
That's exactly what we say, my lord. And I've checked my notes, and I don't believe that this XSA point or magic to be attributed to the word exercise was ever even raised by the al-Malkis first time round.
It is relevant to the point you're no doubt coming to as to whether the link with Article 42 and what's prohibited is an important limitation on what's covered by this exception, because that does seem to concern carrying on of some activity by the diplomat which is incompatible with his or her exercising or carrying out their functions as a diplomat.
I'll certainly be coming to Article 42. On this point, it just begs the same question we would respectfully submit. On my lady's last point as to something incompatible with the diplomat's functions, that's very strongly, we would say, in our favour, if that's the test, if that's the touchstone, for the reason I emphasised earlier, as I'll seek to show the Court in a moment. No part of the Vienna Convention on Diplomatic Relations shows anything to suggest that any part of this has anything to do with discharge of functions by the diplomat. And indeed, in that respect, we're supported by Lord Sumption's analysis of the meaning of the words outside official functions. But in terms of whether there's any magic in the word exercised, we say that the Article 42 reference doesn't add anything. And then, as I say, Lord Wilson emphasised the breadth of the definition of trafficking at 61 to 62. I note in passing also again the US case law that we'll come to in the context of state immunity and whether, again, a state has carried on commercial activity, the words used by the relevant United States statute. No difficulty at all in United States courts reaching the conclusion that an embassy who enters into an employment contract has carried on employment activity. So there's no magic to 21.2 and the word XSA. So going back to 21 and the core points that Lord Sumption makes, 21.3 is next. And this is my lady's point, or the point my lady's just put to me about Article 42. Where Lord Sumption considers that his interpretation of commercial activity in 31.1c is supported by the words for personal profit in Article 42 of the VCDR. And he cites Mr. Justice Law's decision, as he then was, with approval in that respect, the Prop End case. Now, I'll come back to Article 42 and Prop End in detail in a moment when looking at the text of the VCDR and making specific submissions directed to Article 42. But we say that that was a flawed approach to interpretation. We say it was a flawed approach because the words for personal profit were not used in Article 31.1c at all, and they should instead be presumed to have added something by their inclusion in Article 42. Indeed, if Lord Sumption's approach were correct, and the exercise of commercial activity properly construed means trading on one's own account and setting up shop, it is difficult to see what purpose is served by the words outside his official functions in Article 31, because trading activity by a diplomat on his own account and aimed at personal profit by setting up shop would by definition be outside his official functions. But in any event, to the extent that reading 31 and 42 together shows that a profit element in any activity is required for it to fall within Article 31, then it was present on the assumed facts here, given the current context, given the trafficking context, and given the significant and intended financial gain enjoyed by Mr. Basfar in his treatment of Miss Wong. As Lord Wilson summarised the position in paragraph 59.5 of his judgment, the perception of immunity in relation to trafficking with a view to domestic servitude makes it a low-risk, high-reward activity for diplomats.
Well, commercial activity is almost by definition something done for profit. It may be a professional activity you can do pro bono or for charitable public service reasons, but perhaps you could even engage in commerce for that, but it's hard to envisage how.
My Lord, I take that point, but we of course say we've got the profit element needed here if it's needed. As a matter of strict construction, we say commercial activity within Article 31.1c should not impute the concept of personal profit. The words aren't used, and again, I'll come to it in more detail. Well, there are a range of examples one can give as to why a diplomat should not have immunity if engaging in what is otherwise properly characterised as commercial activity or professional activity simply because they don't personally profit. What about the lawyer who gives pro bono advice, which is negligent? What about the doctor who gives pro bono treatment, which is negligent? Should they have immunity? We would say...
Presumably he doesn't make a profit, and therefore he has immunity. I mean, the concept of profit is referred to in the Nicaraguan case, the Costa Rican case, and it's a useful dividing line between public service, for instance, or voluntary service and commercial activity, the concept of profit.
I accept it can be relevant, my Lord, and if it's present, it's definitely commercial activity. The question is, is it a requirement of a correct interpretation of Article 31? And there are two. I hope I'm not overly.
You don't need to go there.
I don't need to get that far, we say. But even if I did, we have the fact that the words aren't used in one article and they are in the other. We have the fact that from a policy perspective, it's difficult to see why the diplomat who dishes out the same negligent advice is immune simply because he doesn't get a fee for it, but not immune if he does get a fee. And the same goes for the medical treatment. So that's, as I say, I'll come to 42 in a moment because I entirely accept it's an important aspect of the Vienna Convention on the Law of Treaties exercise. And I'll come also to the Nicaraguan case.
But it does refer to profit as being an element of commerce in that case.
It does, my lord, yes, but we would say not exhaustively, not definitively.
Okay.
21.4, the Travo. Lord Sumption previews his analysis.
Sorry to interrupt, I'll be quiet after this, but I don't see how it's different from ordinary employment, really, unless you're profiting from exploiting somebody. I mean, perhaps that's a wrong point, but
no, it's a point which is of obvious relevance, if I may say so, my lord, to the ultimate issue in this case, in the context of a case about trafficking. But on this narrow question as to how one interprets Article 31, the question is, where do we get the requirement for personal profit in Article 31? Now, one answer to that might be, well, you get it from the words commercial activity. You don't need any more than that. If that is so, why do those words for personal profit have to feature in Article 42 at all? They could simply have said, a diplomat is prohibited from any commercial activity.
Well, because of professional. Isn't professional also in the other article?
Professional is in both, my lord, yes.
Yeah. And so there's a
that would be one reconciliation.
Pro bono lawyer in your example.
That will be one reconciliation, my lord. Commercial activity could embrace, maybe then there's a difficult distinction between what's commercial activity, what's professional activity, but contemplate the example of a diplomat who provides advice or services in an investment context for the purposes of the gain of someone else, but not him. Is that commercial activity? Is that professional activity? Where's the profit element come in?
You rely on the profit made by Mr. Basfar by employing or engaging whatever Ms. Wong at what level of pay? Any level of pay that's below the UK national minimum wage? I mean, suppose she was being paid the national minimum wage that was applicable in his home state, so he, which may be much lower than our minimum wage because the cost of living back there is much lower. Is he still profiting from engaging her at that lower wage?
Well, he's profiting in both contexts. As to whether what he's doing is commercial activity for the purposes of the Vienna Convention on Diplomatic Relations, that's the key question. Now, if one took the Canadian Labour Code approach, the state immunity approach, and the employment didn't relate to official functions, then we'd be in commercial activity territory anyway. But even if we're dealing solely with a minimum wage case, then that is, we say, materially distinct from this case. A case involving no more than a failure to pay the minimum wage would not carry with it the other commercial elements of a trafficking case. It wouldn't carry with it the treatment of a human being as a commodity. It wouldn't carry with it, and this is to go back to the point I sought to make in response to my Lord Legate, it wouldn't carry with it the ongoing extraction of value by virtue both of the non-payment and the circumstances of confinement and coercion. The employee facing a situation where they're not being paid the minimum wage has the opportunity to walk away. That's not the case in the trafficking context. They are condemned on the assumed facts to an ongoing exploitation and realization of value. And significantly too, my lady, in this context, and this is to go right ahead to a later stage in my argument, but in the minimum wage context, we wouldn't have in our armoury on this appeal what we submit to be the high public policy imperative reflected in all of the relevant international instruments of eliminating the practice of trafficking and providing a remedy to its victims. A network of legal rules signed up to by virtually the whole of the international community, including, for relevant purposes today, Saudi Arabia and the United Kingdom. And we respectfully submit that it's ultimately reductive to say that this case is analogous to a case which only involves sub-market wages of whatever level, because essentially of the three stages of my argument put together, human trafficking within the international definition is a distinct, defined, identifiable, globally recognized commercial activity. It amounts to a course of conduct using exploitative means to extract an individual's value with a view to financial gain. And to go back to its core, Lord Wilson, Ransef and so on, it's treating an individual as a commodity. Now that's very different from a minimum wage complaint. So I was going on to 21.4, where Lord Sumption previews his view of the Travo. And as to that, and I'll of course come to them, but we say the Travo are very much more nuanced and less clear than Lord Sumption's analysis suggested. Most obviously, they did not consider the implications of involvement by a diplomat in the slave trade, as it was then understood, at all, or necessarily in human trafficking. And so we say we're right to say, as we do in our printed case, that you have to approach the Travo with caution. And we say we're right to submit, as we do, that as a matter of domestic authority, Lord Wilberforce in Fothergill, you need to have clear and undisputable guidance from Travo before they can be relied upon to resolve the material issues before the court. And we're well short of that, we say.
What's the page reference for that?
Fothergill, my lord.
Yes.
If you give me 1 second, excuse me.
Not to worry.
No, it's my fault, my lord, for previewing my arguments too early.
Don't worry.
I will give you, it's EF, page 206 is the reference, and then it's that to the report, and it's page 2053, Lord Wilberforce at 278B of the report itself. So that's the Travo, and as I say, I will look at them in more detail later, but just to confront Lord Sumption's analysis and the 6 elements of it. 21.5, he then summarises what he considers and what he states to be obvious reasons why, this is back to EF 876, obvious reasons why Article 31.1c should have been limited, as he put it, to someone participating in a commercial business. Now, again, that of course begs a number of questions, but in terms of his obvious reasons, he stated in this paragraph that it was not inherent in the concept of jurisdictional immunity that it would enable the diplomat to exercise a distinct business activity in competition with others, while sheltering him from the modes of enforcing the corresponding liabilities which are an ordinary incident of such an activity. Now, as to that, we say first, it might also be said, with respect, that it's not inherent in the concept of jurisdictional immunity that it should enable a diplomat to enter the labour market for domestic staff in a manner involving human trafficking, while sheltering him from modes of enforcing corresponding liabilities which are an ordinary incident of such an activity. And secondly, we say that's particularly clearly so in circumstances where we know, thanks to the Supreme Court's decision in Benkabush, handed down on the same day as Reyes, that there is no requirement in customary international law for states to be afforded jurisdictional immunity in respect of the employment of domestic staff. And where we also know from the Palermo Protocol, the Anti-Trafficking Convention, and the ILO's 2014 Protocol, the very high importance attached by the international community to victims of trafficking being able to obtain effective redress. And each of those points are among those made by Lord Wilson at 60 to 66 of his judgment. And thirdly, and in any event, the phraseology used by Lord Sumption in this 21.5, I should say, is with respect imprecise. It is not accurate to say that a finding that there is an exception to jurisdictional immunity would expose a diplomat to ordinary modes of enforcement. As Article 31.3 of the Diplomatic Relations Convention makes clear, even where a judgment is entered against an individual diplomat, no modes of enforcement may infringe the inviolability of his person or his residence, as provided for by Articles 29 and 30, back to the core immunities I mentioned right at the outset. 21.6 in Lord Sumption is where essentially the public policy concern he invokes is identified. And it's really the beginning and the end of the suggested distinction, we say, with the context of state immunity. Lord Sumption suggests that a wider scope for the commercial activity exception than he was prepared to contemplate would expose diplomatic agents in post in the United Kingdom, potentially British diplomatic agents abroad, to local proceedings not only in respect of their employment of domestic servants, but in respect of any transaction in the receiving state for money or money's worth. And that is, we say, and as I've already attempted to submit, not accurate as a summary of the implications of a finding in Miss Wong's favour for at least 4 reasons. Firstly, it overlooks, or at least fails to give any weight to the fact that at least some exposure to legal proceedings is on any view treated as acceptable within the scheme of the Vienna Convention on Diplomatic Relations. As is obvious from Article 31, as I've already emphasised, diplomats do not enjoy absolute immunity from civil jurisdiction. Secondly, it overlooks the preservation of the core immunities of inviolability and immunity from arrest, and the significant protections against enforcement which would remain in any event and which I've just referred to, as well as the untouched immunity from giving evidence in any local proceedings. Thirdly, it overlooks the fact that a finding in Miss Wong's favour as to the declaration she seeks, based on the particular context of trafficking, this is back to the exchange I was just having with my lady, would not impact all employment relationships, let alone all other transactions entered into by a diplomat. And fourthly, we say this approach exaggerates in substantive terms and in policy terms the distinction between the position which applies in relation to employment relationships in the embassy state employer sphere, where non-sovereign activity is concerned and where no immunity arises, and the position as it applies to employment by diplomatic staff. In both contexts, serious factual allegations may be made against individual diplomats. In neither context would the individual diplomat be required to give evidence. And yet in one context, it's common ground, see Ben Kabouche, that proceedings are permissible. But in another, it's said that they're somehow objectionable. Now, we're in, to some extent, novel territory here, of course, but on the one hand, there's great reliance placed upon the case law from the United States. On the other hand, by way of example, as to the risk of overstating practical implications, as we've pointed out in our printed case at 63.5, EF page 345, the Portuguese courts have held that individual diplomats have no jurisdictional immunity in respect even of bare employment claims. And there's no evidence of any adverse policy implications or excessive exposure to Portuguese diplomats or other foreign diplomats serving in Portugal. Now, Lord Sumption goes on at the end of paragraph 21.6, going over the page to EF 877, to express his view in the last 6 lines of that paragraph that the interpretation Miss Reyes and now Miss Wong contend for would have the effect that the diplomat's immunity would mean very little. We again, with respect, do not agree. As recent cases in this jurisdiction have shown, immunity would remain on any view in relation to road traffic accidents. That's the Dunn case. As the Barnett case in the bundles shows, immunity would remain in relation to family proceedings. Numerous other tort claims would still be barred by immunity: occupier's liability, nuisance, defamation, personal injury. And single purchases, the final example given by Lord Sumption, single purchases made in daily life, the newspaper or the bottle of milk, would not be caught by Miss Wong and Miss Reyes' interpretation. They might well not be part of a continuous commercial activity in any sense, and it would be difficult to characterise them as intended for ongoing financial gain in the same way as human trafficking is. And they, of course, also, point I've already made, would have no recourse to international rules in a way that Miss Wong is able to. So that, I'm afraid I'll be coming back probably, and I'll try to avoid repetition, but I'll come back to those points as I go through the key exercise of the Vienna Convention of the Law of Treaties exercise that the court has to apply here. I'll go to that now, if I may, but that is our summary of our response to what we understand to have been the key underlying points informing Lord Sumption, and with him Lord Neuberger, in differing from the other 3 members of the court. Now, for the purposes of the Vienna Convention on the Law of Treaties exercise, I'll go, if I may, in turn to the text of the Diplomatic Relations Convention, to the guidance we say we get from comparative law, to the principle of harmonious interpretation or systemic integration, to the other relevant rules of international law, and then finally to the Travo. And I accept, as some of the respondent submissions say, and some of the academic writing says, that it's a holistic exercise, this. Sometimes it's referred to as putting all these factors into a crucible and seeing what comes out in terms of interpretation. Some of it's described as an encircling process. But as a matter of logic, and with that caveat, I think it's right to go through it in the stages that I've suggested. So the treaty, of course, first, the Diplomatic Relations Convention first, and that the court has at EF page 586. And you have on page 587, remembering that one of the confusions in terms of presenting this is that we're dealing with Article 31 in both the Treaties Convention and the Diplomatic Relations Convention. But you'll remember from 31(2) of the Treaties Convention, that context requires regard, of course, to the text and the preamble. Now, the second paragraph of the preamble of this treaty is at page 587, and it emphasises, and we say importantly, emphasises the link between diplomatic immunity and state immunity, with its reference to what we say is ultimately the core foundation of each, the principle of sovereign equality. The fourth paragraph of the preamble on the same page states that the purpose of the treaty is not to benefit individuals, but to ensure the efficient performance of the functions of diplomatic missions, again, necessarily in the interests of states. Now, each of these paragraphs provides support, we say, for the point that Lord Wilson makes at paragraph 63 to 65 of his judgment, again for reference, it's EF page 893, and where he concludes that he cannot readily explain why proceedings relating to a contract of employment entered into by a foreign state will not in principle attract immunity in circumstances in which, if the contract is entered into by a diplomat, it will in principle attract immunity. And each of those paragraphs, each of those passages, cast doubt, we say, on Lord Sumption's dismissal of the state immunity cases we cited in Reyes, and to which I'll come, as not being, as he put it, of much assistance. That's Lord Sumption, paragraph 32, EF page 880. But back to the text of the Diplomatic Relations Convention, Article 1 at EF page 587 then contains a series of defined terms, but of course it doesn't purport to address, let alone define, the central term we're concerned with here, namely commercial activity. And the fact that not even an illustrative definition was set out is, we say, consistent with the submission that the signatory states and the drafters must be taken to have been content to leave the application of this term to the courts of individual states. It's also consistent with the point I'll come to, that an undefined generic term of this nature must be given an up-to-date evolutionary interpretation, having regard to current concepts of commercial activity. And my Lord Stevens will recall the term is actually very similar in linguistic terms to that in the Nicaragua case. Article 3 of the Diplomatic Relations Convention at EF page 588 then defines the functions of the diplomatic mission. None of those functions would face obvious interference through a diplomat being subject to the jurisdiction in relation to claims brought by someone in Miss Wong's position, any more than claims brought by someone alleging they had been in lawful business with a diplomat, or been the victim of a commercial fraud at their hands, or received negligent professional advice from them. Each of those would be scenarios which, even on Mr. Basfar's case, would be squarely within the exception to immunity. And that's why it's critical to emphasise, as Lord Sumption acknowledged when he addressed our arguments, critical to emphasise the nature of our submissions. We're not advocating creation of a new exception. We're not advocating displacement of an established immunity. We're contending for a correct interpretation of an acknowledged and extant exception. It's no part, of course, of the defined functions of the mission requiring of protection that a diplomat be permitted free rein to engage in personal employment relationships of the kind in issue in these proceedings.
No part of their function to commit criminal offence.
No, my lady.
Yet you accept, I think, that there is from road traffic accidents, not part of their function to run people over in the street, but how this helps you, given that those are covered by the immunity.
Well, my lady, it's perhaps a shield rather than a sword in a sense, but the point I'm making here is that if it could be said that that Miss Wong's claim went to an integral aspect of the diplomat's functions, then that would be a powerful point against me in the interpretation of Article 31. And the reason for that is the Treaties Convention says you have to have regard to the object and purpose of the immunity, essentially, in this context. And the object, as we've seen, the object of the entire Diplomatic Relations Convention is to facilitate the effective discharge of function. So if we were in territory where it could be said, plausibly, that construing Article 31 of the Diplomatic Relations Convention in the way we suggest it should be construed would impact materially on the discharge of diplomatic functions, then it would be a much steeper gradient for me to climb. But going to the particular example of criminal liability, that's why we respectfully submit immunity from criminal process is described, see the Court of Appeal in Freedom and Justice Party, as one of the core immunities. Subjecting someone to the threat of criminal process, arrest, detention, and so forth, inevitably carries with it a pressure and an interference with function which is materially distinct from insisting that they are susceptible to the jurisdiction of a civil court in circumstances where even there they have no requirement to turn up to give evidence, and any documentation in their possession and held by them at their residence, for example, would be inviolable. And that all comes from the next provisions in the Convention, the Diplomatic Relations Convention, which we say are material and which support us. And they're the ones my lady's just alluded to in her question to me. They run on from Article 29 onwards, which is EF page 594, with Article 29, Article 29, Article 30, Article 31.2 and 31.3. They maintain a protective regime for the diplomat which will remain in place entirely untouched, regardless of Ms. Wong's arguments, even if they're accepted to the hilt on this appeal. The diplomat's person will still remain inviolable, as would his or her residence. That's 29 and 30. They'd have no obligation to give evidence. That's 31.2. And no measures of execution cutting across those core immunities could occur. That's 31.3. So everything about function, we say, is entirely untouched by our interpretation. And that's important in circumstances where a critical aspect of the interpretive exercise is object and purpose, and where we know from the preamble that's the object and purpose. It isn't to protect the individual, it's to protect discharge of their functions in the interest of the state. That's underlined again by Article 32.1 of the Vienna Convention on Diplomatic Relations, because that provides, this is over the page on EF 595, that provides that it's only a state which can waive diplomatic immunity. So reinforcing, we say, the submission that diplomatic immunity is indeed an aspect of the immunity of the state for the state's benefit. Now, we don't accept that the underlying rationale on this, and I should emphasise, we don't accept that the underlying rationale for state immunity and diplomatic immunity is different. The underlying rationale all focuses on sovereign equality. Now, as a matter of history, articulation of diplomatic immunity is older, and as a matter of case law, there's reference to the diplomat as an individual. But that's a reflection, we say, of no more than the fact that until the 19th, 20th century, states didn't engage in commercial activity. And it's no more a reflection of the fact that states didn't typically employ members of the local labour force in service of the diplomatic mission. So the core rationale, consistent with all of those provisions, is ultimately the same. And now, we're not saying there's a precise overlap between diplomatic and state immunity. Of course, there isn't. But we are saying that they are closely related, and that, as Mr. Justice Laws put it in Prop End and Lord Wilson put it in Reyes, Diplomatic immunity is an aspect of state immunity. And once one gets to that starting point, it becomes much more difficult, we say, to jettison the guidance that's derived from the state immunity context on the meaning of commercial activity in the way that Lord Sumption did, and in the way that Lord Wilson found difficult. Now, the other provision, of course, of the Vienna Convention on Diplomatic Relations, which I have to confront and which requires particular consideration, is the one that my lady put to me earlier, Article 42. And that is at EF, page 599. And as I've already pointed out, Lord Sumption considered that its wording supported his interpretation of Article 31(1)(c) and showed that the concept of commercial activity included within it a requirement that the activity be carried on for personal profit. Now, again, as I've already said, we submit that Article 42, even taken at its highest on that basis, doesn't stand in the way of Miss Wong's appeal, because if there's a requirement for personal profit, it's here. But in any event, we say, looking at this purely as a matter of interpretation and narrow construction, on ordinary principles, it is, we say, quite difficult to see how the inclusion of the words for personal profit in Article 42 indicate that they should be implied into the words commercial activity in Article 31. Now, my Lord Legate posed a possible reconciliation of the two by reference to the idea that personal profit in Article 42 might only be relating to professional activity. That's not how we read Article 42. We read Article 42 as prohibiting any personal profit activity, either commercial or professional. In any event, in Article 31(1)(c), we have, again, professional and commercial activity, both those words being used, and we don't have the words for personal profit. If they're to be implied into the term commercial activity, then it's difficult, we say, to see why they have to be included in Article 42 when they're absent in Article 31. And going back to Article 31, again, the point I've already made, it's difficult to see why or how, if Lord Sumption is right, the words outside official functions have any purpose. Because if commercial activity is talking only about setting up shop for personal profit on the part of the diplomat, it's hard to see how that could ever be within official functions.
I suppose there's two different points, really. One is one may accept your submission that the test of personal profit is not in 31, it's only in 42. But it could still be the case that an element of profit is part of what makes something commercial.
It could be, my lord, yes. And if that's the correct interpretation, we say there's an element of profit here, which is entirely sufficient. I've already suggested what we would say would be the unsatisfactory results of an application and a requirement of personal profit into Article 31(1)(c), at least in the professional context, as a matter of policy in relation to the pro bono lawyer or the pro bono doctor or the pro bono investment advisor. The better view, we say, is that Article 42 concerns a subset of the activity referred to in Article 31(1)(c). And Article 42 is instead making it clear not only that an individual who engages in any form of commercial activity will have no immunity, as we know from Article 31, but also that an individual who engages in such activity for profit, for personal profit, will be doing so not only in circumstances where he's not immune, but contrary to an express treaty prohibition, with the adverse consequences as to their status, which might then ensue in terms of persona non grata declarations and so forth. And then, as I say, the third reason why Article 42 in any event presents no obstacle to Miss Wong's case, consistent with Lord Wilson's approach, we're in low-risk, high-reward territory. There's a profit element present anyway. And this is another area where Lord Wilson's emphasis on the international definition of trafficking and that very specific context with which the court was concerned with then and is concerned with here comes into play. If, as Lord Sumption contemplated and acknowledged at paragraph 45 of his judgment, a person who buys someone with the intention of selling them is engaged in commercial activity, then so too, we say, is a person who recruits, transports, harbours or receives a person for the purposes of extraction and exploitation of financial gain. Both categories are still within the international definition of trafficker. They are as fully implicated in the activity given the breadth of its definition. And they're not merely end users or customers or consumers, as the possible analogies contemplated by Lord Sumption would have them. Instead, as Lord Wilson put it, they're driving the entire exercise. Now, that's probably a convenient moment to address Prop N briefly, if I may, given Lord Sumption's reference to it, and the fact that it's the only previous decided case to have addressed this question. And the court has that addressed in our printed case at paragraph 52, EF, page 341, and the decision itself was at EF, page 763. Before going to the decision, just to summarise, we make 2 points, basically. Although Prop N was correctly decided, we say, on its own facts, insofar as Mr. Justice Laws reasoned that Article 31(1)(c) and Article 42 are identical in scope, we say he was wrong for the reasons I've already given. And secondly, we say that even if the reasoning in Prop N and the wording of Article 2 requires there to be a profit, then it's satisfied here. I should say there's a third aspect of Prop N that we rely upon too, which I've already mentioned. Mr. Justice Law's characterisation of the law of diplomatic immunity as an aspect of state immunity. So, as I say, the decision is at EF 763, and the case concerned the question whether Superintendent Singh, a police liaison officer and diplomatic agent accredited as a diplomatic agent at the Australian High Commission, could be held to be liable for contempt as a result of his alleged breach of an undertaking given to the High Court pending a challenge to a search warrant obtained by the police and following a request for mutual assistance made by the Australian government. Mr. Justice Laws held that Mr. Singh was entitled to immunity pursuant to Article 31 of the Vienna Convention on Diplomatic Relations, and that the exception from immunity relating to professional activity did not apply. He set out the factual history, and then he turned to the issues of law at page 628 of the report, EF page 780. 781, EF 781 to 782, he sets out the material provisions of the schedule to the Diplomatic Privileges Act, including, of course, Article 31. 632 to 3 of the report, page 784, he sets out what he described as the juridical setting in which the Act and the Diplomatic Privileges Act and the State Immunity Act had effect. And importantly, we say, for the way Miss Wong puts her argument, Mr. Justice Laws held at internal page 633, EF 785, that the divide between acts done iurae imperi and acts done iurae gestionis at the heart of the restrictive doctrine of state immunity also underlay the exceptions to diplomatic immunity constituted by subparagraphs A to C of Article 31 of the Vienna Convention, 31(1) of the Vienna Convention. So, not entirely distinct severable regimes, all part of the overall landscape, relevant, we say, once one gets to the harmonious interpretation stage of the debate. He then cites the preamble to the Vienna Convention and concludes at 785 the law relating to diplomatic immunity is not freestanding from the law of sovereign or state immunity, but an aspect of it. 634, he accepts the circumstances in which the immunities might be lost, might not be coterminous, and we acknowledge that, but he repeats his view of their relationship in principle. And then so far as Article 42 is concerned, at 787, 635 of the report, he considers this there, and the plaintiff's argument had been that Mr. Singh had been acting as a police officer and so engaging in professional activity within the meaning of Article 31(1)(c). Now, Mr. Justice Laws rejected this argument by reference to Article 42, holding that the phrase professional commercial activity in Article 42 meant the same as it did in Article 31. And so he referred to activity which might be carried out by the diplomat on his own account for profit. And then as he held at 636, page 788, Mr. Singh was plainly not so engaged, and so the exception could not apply. Now, the result in Prop End is entirely immune from challenge. I shouldn't use the word immune, but unexceptional, I should say. The police officer was obviously not acting outside his official functions. So on any view, the Article 31 immunity was never going to apply. But we say, of course, the reasoning in Prop N shouldn't be applied to the present context because it would create an unprincipled divergence of approach as between state, diplomatic and consular immunity. And, as I say, it would render the words on our interpretation for personal profit in Article 42 unnecessary and redundant. And in any event, we're in very different territory here. There was no basis whatever for contending that the superintendent in Prop N was yielding a personal profit here. That's very different to the context we're concerned with for the reasons I've given. So that's Prop End, and that's Article 42. And that is all I was proposing to say on the first stage of this exercise, namely what guidance do we get from the text, preamble, object and purpose of the Vienna Convention on Diplomatic Relations. We say, having regard to that stage of the analysis, the interpretation Ms. Wong contends for would be entirely consistent with each of those elements: context, object, purpose. The ultimate interests, which are really what are at stake here, the ultimate interest of the state would be protected. There would be no greater interference with a diplomat's functions than is already contemplated and inherent in the fact that Article 31 is not an absolute immunity in respect of civil proceedings. And the diplomat would remain with a series of uncontestable privileges and protections in relation even to these proceedings. So the first stage, we say, strongly supports Lord Wilson's characterisation of this as a rational, legally acceptable interpretation.
Just to be clear, you say if this claim could go ahead, at the hearing before the Employment Tribunal, Mr. Basfar could decide not, in effect, to contest it by not giving evidence, not presenting any evidence or any documentation. If the tribunal upheld the complaint and ordered the payment of unpaid wages or compensation, whatever, that could not be enforced against Mr. Basfar.
I don't go quite as far as the second, my lady.
Right.
I'd say the full panoply of enforcement mechanisms would not be available as against Mr. Basfar, as they would against an ordinary litigant. There is a restriction. There is still some enforcement permissible, provided it's compatible with Article 31. So provided it doesn't cross the line to personal inviolability, provided it doesn't cross the line to inviolability of the residence, enforcement is available. Right. So there could be attachment of a bank account, for example. But material restrictions on enforcement are still available. And then perhaps just to add one further dimension to the options open to the diplomat, there will be nothing to stop the diplomat, even if he didn't want to give evidence himself, going along and making through lawyers whatever submissions he wished to make as to either legal interpretation of relevant provisions or quantum on the face of the evidence as presented. If one wanted any anecdotal illustration of the lack of material interference with the diplomat that's concerned here, one only need look, in fact, at the case of Reyes. We're now 4 years on. The Al-Malkis have not satisfied the Supreme Court's order that they pay the costs of the Supreme Court hearing. The Employment Tribunal entered judgment against the Al-Malkis without their participation for a modest sum of, I think, just over £8,000, and no payment has been made in relation to that. Now, obviously, their position is slightly different because, as the Court will recall, they had left the jurisdiction by the time the case came to be debated before the Supreme Court, so it was a residual immunity case. But the heavens aren't going to fall, my lady, as a result of this interpretation, and there are still going to be substantial protections available to the diplomat. And none of the residual effects get anywhere near, we say, engaging the significant public policy concerns which might favour an interpretation in the other direction, particularly when one starts from the critical first starting point, that Article 31 itself contemplates that, entirely consistent with the scheme of the Diplomatic Relations Convention, civil proceedings may be brought against the diplomat. So that's what we get from the Convention itself and the wording used in the Convention itself.
Just before we move on, Mr. Rodham, just thinking about the purpose of the exception. Is it something along the lines that if you decide to engage in some activity which is nothing to do with your diplomatic purpose here, that there is no reason why you need to be protected against civil claims insofar as you're incurring liabilities in the course of that? That isn't something which is necessary for the protection of diplomats. I find it hard to see that it's anything about giving diplomats an unfair competition, which is Lord Sumption's suggestion. A bit unfair on the others in the market if diplomats have a leg up. One should look at it the other way around. How far does the diplomatic protection need to go? And if somebody's doing something non-diplomatic, basically.
We agree with that, my Lord, with respect as a starting point as to what object and purpose is concerned with. I have to acknowledge, of course, that and it's indeed a point I rely upon, that definition of object and purpose and that identification of object and purpose provides no foundation for the creation of entirely new exceptions to immunity. Just in the same way as it couldn't be said that driving down a road...
No, of course, you can't add another one in the
convention. You can't add another one in.
You're trying to interpret the one we've got
exactly
and to understand how far it goes.
With that caveat, my Lord, I entirely agree. So that's the convention. Then the next stage of this aspect of my submissions that I wanted to go to, and it is what support one gets from comparative law. And it's in that context that I emphasised the difference between, with respect to the way Miss Wong puts her case, and Lord Sumption's analysis in drawing this very sharp dividing line between state and diplomatic immunity, and saying that the state immunity case has really provided no assistance because of that dividing line. Not a view which Lord Wilson, at least, was willing to leave free from doubt. And in that context, we rely upon case law from the Canadian courts and from the United States courts, which have both, as a matter of ordinary meaning, I acknowledge I have to confront, of course, Tabillon and the other United States cases, and I will do so, but as a matter of ordinary meaning, treat the term commercial activity as being sufficiently broad to embrace employment relationships. And that case law has spanned state immunity, diplomatic immunity, and consular immunity. And before going to them, I'll just address and summarise, if I may, our position on Lord Sumption's rejection of the state immunity cases as providing material assistance. And this is Lord Sumption beginning at paragraph 28, EF page 879, I should say. And the first and primary point Lord Sumption made in distinguishing the two contexts was to go back, in a sense, to his point at 21.6 that I've already referred to, and to emphasise here at paragraph 28 what he called the corporeal vulnerability of an individual diplomat as contrasted with the incorporeal state which had sent them. And again, we say that given the diplomat's retention of core immunities, the lack of any obligation to give evidence, which I've already mentioned, it's not easy to see, we say, why a diplomat faces any greater vulnerability or interference with his functions as a result of proceedings brought against him personally as defendant than he would in relation to proceedings brought against his embassy by reference to allegations which concern him. And as I said right at the outset, if the corporeal vulnerability concern were really to be determinative as a point of distinction, that would have justified an approach in drafting the Vienna Convention of Diplomatic Relations which provided the diplomat with absolute immunity from civil proceedings, just as it did in relation to criminal proceedings. And we rely upon the fact that that approach was not taken, and that it was therefore necessarily accepted that some civil proceedings, however ill-founded, assuming it against me for the moment, however ill-founded they might be, as a matter of fact, could be brought. And it shows, we say, that this is a factor which should not have been given the weight which Lord Sumption gave to it. The second point Lord Sumption made in distinguishing the two contexts, state immunity and diplomatic immunity, is at paragraph 29 of his judgment, where he draws attention to the fact that in the field of state immunity, the critical question is always whether the act concerned was of a sovereign or private law character, with immunity attaching to the former but not the latter. Whereas in diplomatic immunity, it's accepted that immunity does extend, at least in some circumstances, to transactions of a private nature, as is evidenced by the closed, narrow class of exceptions in Article 31. But that difference, we say, does not help resolve the ultimate issue. We say instead it merely begs the question. It doesn't immediately show why the term commercial activity should mean one thing in the context of classic state immunity and should mean something radically different in the context of diplomatic immunity, let alone that one can simply disregard the state immunity guidance as irrelevant. And that's particularly so where, as I've just been submitting, diplomatic immunity is like state immunity rooted in the sovereign equality of states and deliberately and specifically designed to serve state interests. As Mr. Justice Laws put it in the passage I've shown the court, the very same iurae gestionis, iurae imperii distinction that lies at the heart of state immunity underpins Article 31. And ultimately, as Lord Sumption's reference at paragraph 30, back to his paragraph 17 and 18 of his judgment show, the real concern underpinning diplomatic immunity is with conduct capable of threatening the discharge of diplomatic functions. And that's back then to the importance, we say, of the analysis that we gain from looking at the text of the Convention itself, what those functions are, and whether one can get anywhere near showing an interference with them. And this point as to the linkage between state and diplomatic immunity is then further illustrated by the direct overlap in recitals set out to the Vienna Convention on Consular Relations, which the court has, I hope this electronic reference works, it's App Sup EF5, Appellant Supplementary Bundle EF5, tab 193 of the hard copies, but I know the court's working from electronic. There you have the Vienna Convention on Consular Relations, with a direct overlap in the recitals I've shown the court from the Vienna Convention on Diplomatic Relations. And as we'll see, we have the accepted position in relation to the Consular Relations Convention, even in the United States, that engagement of a servant for purely personal services would not be within official functions and need not attract immunity. The second, fourth and fifth recitals of the Consular Relations Convention are in the same terms as the second, third and fourth recitals of the Diplomatic Relations Convention. And the third recital in the Consular Relations Convention expressly references the Diplomatic Relations Convention, so further underscoring, we say, the complementary nature of these different regimes and treaties. Now, I acknowledge, of course, that the wording in respect of immunities is different once one gets to that in the Consular Relations Convention. And on the face of the treaties, consular officials have lesser immunity. They have, for example, no complete immunity from criminal process. That's Article 41. They have a lesser immunity in respect of civil proceedings. They have no immunity from road traffic accidents, for example. And they have no complete immunity from giving evidence. And that's a point that can fairly be made by the respondent. But the central point we make here concerns the common purpose of each instrument in serving state interests and goes to the corporeal vulnerability issue. And so the Consular Relations Convention at least provides a further illustration of the fact that the mere exposure to civil proceedings in relation to an individual does not inevitably cut across the ability of a state official posted abroad to discharge his or her functions. So drawing this together...
Do you say that a consular person's immunity would clearly not extend to any employment relationship or a trafficking relationship, or what is the...
Yes, my lady.
Where do you get that from?
If we go to... the wording is different, as I've not acknowledged, but we get the immunities dealt with in relation to civil proceedings, I think at Article 43 of the Consular Relations Convention. And it all hinges, or a more precise answer should be, if the employment relationship is not related to official functions, then there would be no immunity. If you, I don't know whether my lady has the references, App, Sup, EF 20.
Yes, I'm looking at Article 43.
Yes, my lady. So they will not be amenable to the jurisdiction of the judicial authorities of the receiving state in respect of acts performed in the exercise of consular functions. So if Lord Sumption's analysis in Benkabush, which favoured my client, in Reyes, which favoured my client, is correct, that employment of a domestic servant in circumstances not touching upon official functions at all is in play, then there would be no immunity there.
Maybe employment of a personal servant is an area where attitudes may be evolving. Once upon a time, it might be thought that having a personal servant was an ordinary incident of life, like going out to buy a bottle of milk or something that wouldn't just be part of coming to the country, not some activity or engaging in. But nowadays, we might tend to see employing the personal servant as a more commercial type
more of a luxury.
More commercial type of activity, well, maybe.
My Lord, yes, but Lord Sumption grapples with this to some extent in distinguishing between what might or might not be useful for a diplomat and what might or might not properly be characterised as within their official functions. And his view was that employing a personal servant to help at home in work that didn't touch remotely upon the diplomat's actual job was not within official functions. We also get, on this particular point, there's the case of Park and Shin, which is the US case on employment relationships in the consular context, which I'll come to, and it may be that I can more effectively try to assist my lady when I get to that.
Here's another way of looking at the relationship between the purpose of immunity and the exceptions to immunity. Not that the exceptions are simply aspects where the lack of immunity does not impinge in any way on the performance of your function, but aspects where those parties to the convention have concluded that other considerations ought to have a higher priority. I mean, speaking myself, it would seem to me that the exposure to any form of litigation in the receiving state, whether it's giving evidence or being made a party or having to plead, having to go and instruct lawyers, is capable of interfering with that person's performance of his functions. But that there are certain aspects of liabilities which a diplomat may incur in the receiving state where, for other reasons, he's just not. The world has agreed that he should not be immune.
My Lord, I acknowledge the instinctive reaction, first of all, as to the potential for any exposure to civil proceedings to interfere. And if that had been the controlling factor in the minds of the drafters of the Vienna Convention on Diplomatic Relations, that would have led to the immunity from civil proceedings mirroring that for criminal proceedings. And we wouldn't be here because there would be no tenable argument. I wouldn't be able to say this is all dreadful, please create an exception to that immunity. But once one starts the analysis at the correct point, which is, we say, that those drafting the convention and those states signing up to it have contemplated that it is not an unacceptable interference with diplomatic function for there to be some exposure to civil proceedings, we're in entirely different territory. And it then becomes only a question of interpreting what those exceptions say. And when we're dealing with an undefined exception, commercial activity, it may be that other factors come in. And looking at it from one end of the telescope, you could say, well, applying Miss Wong's approach, what would be the implications of that for discharge of diplomatic function, object and purpose? And are they any more serious than the implications of a claim in the commercial court alleging that a diplomat has been engaged in commercial fraud? We would say no, which tells you that that doesn't present a barrier. If you approach it from another end, or another perspective, look at it through another prism, which at least has some support in the materials, and test it by saying, well, is this particular activity to be characterized as something which is not only not in service of the diplomatic function, but it's actually repugnant to it, incompatible with the dignity of the embassy, incompatible in that sense with the mutual respect between sovereigns? The answer, again, we say, favours Miss Wong. So, as I say, we wouldn't be here. My argument would be impossible if the Convention itself conferred the same absolute immunity from civil proceedings that would be consistent with the concern my Lord's identified.
Well, of course that's right, but my concern was not in the sense to say, well, because all forms of exposure to litigation appear to detract from the diplomat's performance of his functions, therefore any exception should be as narrowly construed as possible. My concern is that one may be missing some other purpose behind the exception which justifies a derogation from the purpose of the immunity.
Well, perhaps the other element, which is reflective, or at least perhaps responds to that, is you're looking at a deliberate act on the part of the diplomat.
Yes. I mean, he goes out there and exposes himself to a liability by engaging in certain activities.
Exactly. So he has taken the plunge into the waters of trade. He has, on our assumed facts, engaged in conduct which constitutes trafficking, international trafficking, according to a definition his own kingdom has signed up to. And that's where, again, it's the crucible approach, and one has to put everything in before reaching a final view. But all of them, we say, point in the same direction. So I was dealing, I think, with Lord Sumption's points in seeking to separate out state immunity as providing any material assistance. And we say, once you put together state immunity, consular immunity, diplomatic immunity, they all point in the same direction. I'll come to the individual cases to the extent I need to, but they show three things. They show other senior courts in respected common law jurisdictions treating the literal meaning, that's the US cases, or the ordinary meaning, that's the Canadian case, of the words commercial activity as sufficiently broad to embrace even a bare employment contract in what is, at least we say, the related context of state immunity. They show that, we say, that they support the submission that the position should be a fortiori for an employment contract bearing the hallmarks of trafficking and commercial gain and exploitation, or as Lord Wilson put it, high reward for the diplomat. And they show, we say, that it's wrong in principle to treat state immunity as irrelevant to the correct interpretation of the Vienna Convention on Diplomatic Relations, where one is an aspect of the other. And that is particularly so, and this is a point I haven't made yet, so I should emphasise perhaps at this stage, that is particularly so where the delegates charged with the negotiation and agreement of the Vienna Convention on Diplomatic Relations in 1961 would have been very well aware, in including an important but undefined exception to immunity for commercial activity, of the movement towards restrictive immunity underway in relation to state immunity, based upon the Jure Imperii, Jure Gestionis distinction. A distinction which has been characterised and translated in leading jurisdictions as being between sovereign and commercial activity. We'd had the United States State Department Tate letter in 1952 making that distinction. We'd had Sir Hirsch Lauterpacht writing about it as being well underway as a movement in the early 1960s, and we of course get to Trentex later here in the 1970s. So that's a movement which is underway, which can't be simply ignored, we say. Now, the primary cases that Ms. Wong relies upon in this regard are those we've referred to at paragraph 45.5 of her printed case at EF pages 338 to 339. She is, in addition to those cases, Canadian Labour Code, El Haddad and the others from Canada and the United States, she's in addition to those, we say, able to draw assistance even from the case of Tabion, the principal United States case cited against us, and from the Park and Shin case, the consular and state immunity case that I mentioned earlier. Now, I'm not going to go to the Canadian Labour Code case and the El Haddad case in detail, I don't think, in the interest of time, unless it would assist the court. The context, I acknowledge, was different. The context was construction of the term commercial activity in relation to a domestic statute in Canada in the context of state immunity. But the point we make is a very simple one, that in that context of state immunity, the Supreme Court in Canada had no difficulty acknowledging that bare employment contracts could fall within the term commercial activity. And just for reference, that's the point made by Justice LaForest at page 79, E4130. We also get the point. There's a cross-reference
Sorry,
to...
could you give that reference again?
Certainly, well, it's E4130, page 79 of the individual report itself. Secondly, from the Canadian Labour Code case, we get the fact that activity can be entirely adequately satisfied by entry into a single employment contract. And that much is reflected, again, I acknowledge, in the context of interpreting a domestic statute both in the United States and Canada. But there's no inherent difficulty with the idea that activity could be a single employment contract, at least from that perspective.
And the page reference for that?
Yes, my lord, that is EF page 4115 by internal letters D and F.
Thank you.
And it's no answer in this context to say, as Mr. Basfar does in his supplementary submissions from last week, and indeed as Lord Sumption did, that this case, the Canadian Labour Code case, was really only reflecting the de jure gestionis, de jure imperie distinction. That doesn't avoid the fact that the court had no inherent difficulty in characterising an employment contract as falling within the ordinary meaning of those terms. And if, as we acknowledge was the case, the court was treating the term commercial as reflective of the jus gestionis, jus imperii divide that I've referred to, that only underscores, we say, why those individuals involved in the drafting of the Vienna Convention of the Diplomatic Relations Convention halfway through the last century should be treated as having the same contemplation in mind. So that's state immunity. I'm going to say something about consular and diplomatic immunity too, so far as comparative law guidance is concerned. The next American case that we rely upon, in addition to the ones set out in the printed case, is the Court of Appeal's decision of Park against Shin. And in that case, again, the court held that the hiring and payment of the claimant in that case was a commercial activity. Now, this decision addresses, in fact, both consular and state immunity, because Mr. Shin ran the case that not only was he entitled to immunity under the Consular Relations Convention, an argument that was rejected, he said also he was entitled to immunity on the basis of state immunity because he should be treated as a state himself, which perhaps was an ambitious submission, but it failed in any event, and it failed because the court held, as it did as it would in Benkabush here, as we see, that states just don't have immunity of that kind. Now, the judgment is a very brief judgment. It's at App Sup EF, page 95. And the plaintiff, Miss Park, had brought a series of employment-related claims against the...
Could you give the page again?
Sorry, App Sup EF, page 95.
95, thank you.
Miss Park had brought a series of employment-related claims against the Deputy Consul General of Korea in San Francisco, Mr. Shin, arising out of her tenure as his domestic servant. And as I say, he claimed he was entitled to immunity both because his engagement of Miss Park was within his official functions and because he was to be treated as an agent of the state and so entitled to state immunity under the Foreign Sovereign Immunities Act. And both of those arguments failed. So far as the first is concerned, the court held, like the Supreme Court did in Reyes here, that despite the fact that Miss Park's employment might be of use to Mr. Shin in allowing him to fulfil his other functions, that was not sufficient to render the employment in the exercise of consular functions. And we get that from paragraphs 8, 13 and 17 to 18 of the judgment. And then importantly for present purposes, the court also held that the hiring and payment of the plaintiff was a commercial activity carried on by the state, even if that term was wide enough to embrace the defendant for the purposes of the Foreign Sovereign Immunities Act. That's paragraphs 27 32 and 36. There are 179 parties to the Vienna Convention on Consular Relations, including both the United Kingdom and Saudi Arabia. And again, as with state immunity, the position, as I submitted earlier, the position under the Consular Relations Conventions, we say put into proper perspective any assertions or public policy concerns as to damaging consequences of this appeal succeeding. And go, again, we say, to support our position on the lack of decisive weight to Lord Sumption's corporeal-incorporeal vulnerability distinction. My Lords, we're going to turn next to Tabion. That may be a convenient moment.
I think so. 2 o'clock.
Thank you.